Well, good morning, everyone, and welcome to Aging a Family Affair, the second part of our virtual webinar series. This is part of our 36th annual Aging a Family Affair, and it looks a little bit different this year, as you can tell, and I'm getting feedback, so hold on one second. Okay, we're going to try that again. Technology issues sometimes are fun. So this year looks a little bit different, but we're so excited to bring you this series for Aging a Family Affair, and we're so glad that you all are with us today. If you didn't join us last week, we had a presentation on Medicare Update, and that is available, if you missed it, on our website at knoxseniors.org. And next week, we will be having our third in our series, which will be looking at the spectrum of normal aging versus Alzheimer's disease by Dr. Monica Crane, and that'll be next Friday, the 20th at 10 a.m. If you're interested in that, you can call our office at 524-2786, or you can register through our website at knoxseniors.org. Just a couple things before we get started with our main event today. You are muted, and so you will remain muted for the duration of the presentation. That's to help with various background noises that often occur during our meetings. And we will invite you to unmute yourself at the end of the presentation so that you can ask questions of our speaker. For those of you that may be joining us through the internet, you are welcome to turn off your video. You can do that usually at the bottom of your screen. It says stop video. You can also change your view in the upper right-hand corner to just the presenter and the shared screen if you don't want to see all the grid of people that are calling in or that are on the internet watching. Please take advantage, for those who are on the online version of our webinar, to use the chat function to ask questions of our speaker, and he will address those at the end. If you have questions also for one of us, either Angela or myself, you are welcome to ask those as well. I'm Dottie Livers, the Director of the Office on Aging, and I do want to formally welcome you. And I know you're not here to hear from me, you want to hear from our wonderful speaker, and that's what we want to do now. I want to turn it over to Glen Kyle. He is our speaker today, and Glen is the owner of the Knoxville Law Office of Franklin and Kyle Elder Law. His practice is the specialized field of elder law, which includes life care planning, Medicaid and Veterans Benefit planning, estate planning such as power of attorney, wills and trusts, conservatorships, probate, and trust administration. And today, Glen is going to be talking to us about planning for the future during a pandemic. And so there will be his presentation, and then again afterwards, we'll leave time for questions. So I'm going to turn it over for our presentation. Thank you all for joining us.
So my name is Glen Kyle. I'm an elder law attorney, and we want to talk today about planning, especially in the time of COVID. As everybody knows, COVID has really changed a lot about our everything from our culture to our day-to-day living. It's been especially dangerous for older adults, right? So one thing that can be really difficult, looking at the numbers, I mean, 80% of the deaths have been for people that are 65 years and up. 60% of the deaths have been for people 75 and older. And there's just, in addition to the increased chances of mortality, there's a large increase in the chance of hospitalization as well, right? So one of the things that we want to do is be able to plan for that if it happens to us, so that we're prepared for that kind of situation. And it's even especially important if you are a caregiver for someone else. So a few of the things that I think that make it especially difficult is not just the increased chance of hospitalization, but social isolation is really, really a challenge, especially for older adults. Being around other people is just critical for our mental health. And because of COVID, if you're around other people, obviously, then that increases the chances that you can have a diagnosis, right? So that can reduce the time you're around or the ability to see family or friends. It reduces social gatherings. It reduces some types of care. Certain types of day programs and things have been a lot more restricted. And so Politico had an article, I guess 2 weeks ago, that showed that they thought with people with dementia specifically, there could be an extra 100,000 people that have passed away, not directly because of the virus, but because of a lot of the social isolation and self-neglect that can come through that. So we want to be able to plan for that as much as possible, and to get our affairs in order so that we can have that, and make sure we're prepared for it. I think it's especially important if you can't drive. And there's also been a major increase in depression and loneliness. And caregiving itself is much more difficult, in an assisted living or at home. So what can we do to actually plan ahead, to be prepared for anything that can come at us? I think the first thing is just to get organized, right? One of the things that we do is we send out a packet before we meet an initial client so that they can write down, their name and addresses and the addresses of their kids and their doctors and what diagnosis or even, sometimes drugs that they have, plus a list of their accounts. And that's really as important for the client as for us, because if we're in a position where, if I had to go to the hospital and be on a respirator, we want to be in a position where somebody can come in and know what I know enough of what I know so that they can manage my kind of necessary parts of my life for me, right? One of the real difficulties we have in a normal situation is if somebody has a stroke, and then a family member or a son or a daughter a lot of times has to come in, sometimes from out of state, and they don't know what the diagnosis the parents have. They don't know where the money is, right? And so we want to have it where we got an organized situation. Now, that doesn't mean you have to tell them everything, and we'll get to that in a second, but having it in an organized place is really important. The second thing is to make sure that your estate planning documents are updated. And so that's going to be things like a power of attorney or advance directive for healthcare, or even a will, right? So those are the documents that allow somebody to manage your affairs for you, give you the legal rights to do it. Just being someone's daughter or just being somebody's spouse does not give you that rights to act on their behalf, right? That's what the power of attorney and the advance directive or the healthcare power of attorney do specifically, right? There are also, again, special considerations if you are a caregiver, because you need to make sure that not just your needs are taken care of, but also the person that you're caregiving for, right? We do a lot of planning, looking at the caregiver's care. The person they're caregiving for care, but what happens if something happens to the caregiver? Who's going to know that? Who's going to be able to step in? What are they going to need to know to stand in, right? Similarly with financial planning, right? We want to make sure that we've got everything the correct way and that we're prepared to go forward. One thing I want to talk about just at the outset is planning ahead doesn't mean gifting, right? That doesn't mean to give away your things. You're the one that you and your spouse, maybe you're the ones that worked hard. You're the ones that went without to invest it. And that's where, the money that you have is really yours, right? And so giving things to your family, can have a couple of negative effects. The first one is if you did have COVID or had a medical event where you needed long-term care, long-term care is not paid for Medicare generally. It's on Medicaid, and with Medicaid, there's rules. You can't have too many assets, and if you give them away, you can be penalized for that. And so you can be at the point where after you're already spent down, in other words, you have a few enough resources to qualify, You can't get that help paying for help at home or the assisted living or nursing home through TennCare because they're going to hold the gifts against you. In addition, I've had situations where you give the assets to the child spends them, or the child gets divorced, or the child gets sued, or goes through bankruptcy. And in any of those situations, the house or the money is going to be basically gone. It's not there for you. And then finally, especially with land, there's an issue with capital gains, right? Whatever you bought an asset for, when you sell it, you have to pay taxes on the difference for what you bought it for and what you sold it for. If you live in a house, then you can ignore the first $250,000 in gain per person. But if you own it at death, the basis goes up to what it's worth when you pass. But if you give it to somebody while you're alive, they get your basis. And so, especially if you've owned a house or a farm for a very long time, that difference between giving it during your life and having it when you pass, I mean, it can be it can be tens of thousands of dollars in difference in taxes. So always, before you make any type of gifting like that, you want to speak to a professional about it. So what does it mean to get organized? One thing we talked about was having a sheet where you write everything down. That can be a spreadsheet or a notebook, what have you. But what we're talking about specifically is what somebody would need to know about you if they need to step in and act on your behalf, right? So on medical, you want to have a list of your diagnoses. You want to have a list of any care that you're getting or that you need, a list of your doctors, a list of the drugs that you're on, right? And a list of all your specialists is where you want to have that, so that somebody knows if there's specific issues that you have, that if they're not treated when you go into a hospital, you want to have those noted as well. Some people have to be turned, regularly, or they have Sjogren's, so they have to really have more, hydration. But that's an important thing to have there, that somebody would need to know if they stepped in for you. Right? If you're caregiving for someone else, it's important to have that information down for both of you. Also have your financial life there. I think it's really helpful to have one statement from each of your accounts. I don't think you need all of them, but you want to know if somebody steps in to need to help you, they need to know where your money's at, what financial institution, what's, and what the balances are, and what the account number is. You're the one that saved the money, and so it's your money. But if nobody knows it's there, if you're in a position where you're, in the hospital, nobody knows to get it. And so a lot of times, if we have a sudden event, then we would wait to see the statements come in the mail. Right. But now a lot of people are doing online statements. So the statements may never come in the mail. And if nobody knows where to look, then they can't really access your finances. So that can be really, really difficult. If you have an investment advisor, I'd have his or her name in there too, or a tax preparer, right? Because that's somebody that can help your agent with you. And then, of course, if you have estate planning documents, power of attorney, advance directives, wills, I'd have a copy of that. You want to have the original in a safe place, but which could be there. It could be in in a safe deposit box or a fireproof box. But at least have a copy right there in that same place. A lot of people put their internet logins in there. Especially for your emails and things like that. So somebody could check your finances, or your bank, sometimes, potentially some financial information there. If there's specific information on how to access a house or a safe, I've had a number of issues where we had a number of times where somebody had their will and their fireproof safe at the home, which was really great. But then when we needed to get in there, nobody knew the combo. And so we were in a position where it makes it really, really difficult after that person passes to get their important documents together so we can move forward. And so that can be really important. Now, when I say put it all together, I don't think that means you have to go to your agent. And agent, when I'm saying that word, I mean the person you're appointing, say, under a power of attorney, and give them all of that information now. Privacy is really important. And, certainly if you want to have that conversation with the person, feel free to do it. But I don't want you to feel like you're forced to do that, right? The purpose of having a lot of these documents and having this together is so that in an emergency, the person can step in. So a lot of times I would just tell you to, or recommend my clients to have a cabinet or like a filing cabinet or just a drawer where they put all this information together, and they may not have to give it to the agent now, but let the agent know where it is, right? If there's a key to get into that, let them know where the key is. And so that way, if there is a crisis, there's somebody that can step in and get your things together and move forward, right? As I mentioned before, I think this is especially important if you're the caregiver, right? Because if something happens to you and you go to the hospital, somebody needs to know that you're the caregiver for someone else and be in a position to step in, especially if that person has dementia and they may not be able to do it for themselves. The first thing I'd always recommend is if you're the full-time caregiver, having a personal response system for you can be really important in case you had a fall, so that you can get help not just for yourself, but the person you provide for, right? I think it's important also to have a plan for who would provide care and how to notify them if you got COVID and had to go to the hospital. Sometimes that's having a caregiver service that you've got a relationship with and that, that you could call. Other people, that's other situations. We'll use an assisted living facility. You can get respite care for a number of weeks. And so sometimes having an idea of which one you would use in that situation, that you would prefer at least, if they have an opening, can be really useful and have that number down, especially if you used them before, right? And again, if you are the caregiver, it's important to have a backup caregiver to some extent, and having these discussions with them about kind of plan A, plan B, plan C is really important, because that's one of the things of all of this is going to be, we're going to plan for what can come down, but all of it really comes down to your health, right? In a really big way. So it's important to have kind of a plan A and a plan B, and sometimes even a plan C, because depending on your situation, it's going to kind of depend on what level of care we're going to need. I think it's even more of a challenge when you're caregiving for someone who doesn't live with you, right? If you've got a parent or a loved one or a sibling who's in a different home, especially if they're not able to drive or especially if they have some dementia diagnosis, then a lot of times one of the important things is making sure that someone else is there to just check in on them, right? And arrange for food can be important too. So one thing that you can look at doing is having food and goods delivered directly. Now this can be challenged for people that don't have internet connection. But I got to say, that's been the only good thing for me from COVID is I've realized that I can get my food delivered to my house and I don't have to shop anymore. I don't like doing that very much. So that's been kind of a positive thing. But sometimes having that set up can be important. Having daily calls to the person that you're assisting, and that can be from friends or family, or the area office on aging has a wonderful program for that makes a big difference. But just making sure that somebody that's at home is getting some contact every day in case there was a bad fall or something happened. We want to be able to know about it so that we can get care, as soon as possible. And Meals on Wheels is wonderful because it does both, right? Both will have somebody that can come by and knock on the door, which is wonderful. Plus, it provides the nutrition that's so important. It's just one of, if not, well, I don't want to. I'm a little biased because my aunt, delivered for decades, but I think it's just one of, if not the most important program that we have in most communities. I mean, it's just it does an unbelievable amount of good for so many people. But that can be a really important kind of a check-in and nutrition, provider. In addition, a lot of people are using a lot more technology now, which is good. I mean, anything from having Alexa to Ring to if you're homebound, using telehealth now. Medicare has expanded its ability to that, so you can talk to the doctor if you have the internet without having to go in. Those are all big advantages you can have. Some people that might have mild cognitive impairment or early dementia, sometimes the Alexa can remind them to take their pill at a certain time. It can be really beneficial as well. So those are all, I think, things that are not, like estate planning themselves, but can be really important to have a plan in place if you need the help. But we're still at the position where I can tell somebody what I need and I can tell them where my finances are, but unless I've given them the power to actually act, they're going to be really limited on what they can do, right? And so that's where we get into the estate planning documents. For many people, really the most important one is the power of attorney for finances. That's while you're alive and only while you're alive. When you pass away, the power of attorney ceases to be operative. But it's going to appoint somebody as your agent to make financial decisions for you. Now, I think it's really important to realize that having a power of attorney itself doesn't remove any of your rights, right? You're appointing somebody to act for you, but if you disagree with them, what you say goes. And if you get mad enough at them, you can always fire them, right? There are kind of two different ways that they work when it comes to when the agent can act, right? One's called springing and the other one's immediate. So when you sign a power of attorney, that document is effective, right? I mean, the document itself is valid the second you sign it and have it notarized, right? But there's a question of when the agent can actually act on your behalf. So probably the more common one is to have an immediate power of attorney. The second you sign it, that agent can act on your behalf immediately thereafter, right? And what that means is they could go to the bank and they can have their name added to your account as an agent, and then they can write checks and they can make deposits and they can manage your real estate. They could sell it, or they can sign contracts, or they can do your taxes or talk to insurance companies. Those are all really important activities, right? And what I should say is that even if you're on someone's checking account, which again, I don't recommend, that'll allow you to access that account, but that doesn't mean you can sign contracts for them. That doesn't mean you could check them into, an assisted living community. That doesn't mean that you could do their taxes. A power of attorney is what allows you to do those, those things for them. But to go back to springing versus immediate, so immediate, the second you sign it, the person can act. Springing, the second you sign the document, it's a valid document, but the agent can't actually act with it until something else happens. And generally speaking, that's going to be a doctor stating that you can no longer manage your affairs. Now, this is one of those powers that's customized. Different power of attorneys are going to use different language on that. Personally, I would recommend that you only have one doctor if you're going to use that. I've seen ones that'll require 2 doctors or even 3 doctors, and that can be really difficult because, generally speaking, your primary care physician might sign that, or a neurologist or a gerontologist, but it can be really hard for people that don't have those additional doctors to get someone to sign. I mean, having an appointment with a doctor just to have this evaluation is really, really difficult, and a lot of other specialists just won't sign this. And you can understand that if you're a pulmonologist, you might not feel like this is something that's particularly in your wheelhouse, right? And so that's an important distinction. I will say both of them have their place, but financial institutions like banks can be hesitant on power of attorneys in general. And so a lot of times they will try not to accept them. And I say that as an ex, I worked in banking for quite a while before I became an attorney. But a lot of times they're more comfortable with the immediate than the springing, right? Because they're afraid that if it's spring into place, it might spring back out of place. But that's something you really want to pay attention to on which way you would want that. The next thing is that it needs to be durable. So the default rule on a power of attorney is that it's only there as long as I have capacity, because in that case I can cancel it at any time, right? But a lot of times what we're trying to plan for is what happens if I'm on a respirator in the hospital, or what if I did have a stroke, or what if I'm at the point where I can't manage it myself. Well, in that case, that's where we really want the power of attorney to be into effect, right? And if we don't have the language that specifically says it's durable, that it's going to continue after a period of incapacitation, then it ends right when we need it the most. I'll also note that it's not enough just to say in the title it's durable. It needs to have that language inside the actual document. Right. I've seen that a few times where banks or it wasn't valid because of that in the situation we were in. One other thing I'll say is, like, as you might have noticed, these aren't one size fit all documents. We do want to customize them, partially for this springing versus immediate, but there's also a number of other powers that some clients will want, some won't, depending on the situation. A lot of that sometimes will come to gift giving. The general rule is that your agent has to use your money on you and only you, which makes a lot of sense, and that's really good. And that's one of the differences on a bank account of having a power of attorney as agent on the account versus putting somebody as a co-owner. Because if they're on your account as an agent, it's still your money, right? It's not their money. And so, but if you put them as a co-owner, it's now their money too, and that's why it can be attached. If they did have some financial issues or potentially divorce and situations like that. But sometimes we do want to be able to make some gifts. Like if you're generally tithing, you might want to be able to continue the pattern of gift giving you've made before. In addition, if one of you needed long-term care, like in-home caregiving or assisted living or nursing home, again, Medicare is not going to pay for that, but the Medicaid program can. And there are ways that, elder care attorneys like myself can work with a family to sometimes transfer assets legally between spouses, or in some situations with children. And to do that, it can be beneficial to have a more broad power of attorney that gives, more gift-giving ability, but in a way that fits with the general estate plan in a trust or in a will. So that's something we want to customize with each of our clients, because you can imagine also that can also, in certain other situations, lead you to a position where you're more liable to be abused, that power would be. Right. So we want to look at that each time. There's a couple of things that I want to talk about now about power of attorneys, but they're going to apply just as much to an advance directive or a will. It's really important to look at the agent you're selecting, right? What are we looking for? You have to kind of think about this sometimes as like almost a job interview, right? You're looking for someone that's organized, that has good record keeping. You're looking for somebody that's completely honest, somebody you would literally give your wallet to or your house to and walk out of the room, right? Because that's kind of what you're doing. You want to have somebody that's, preferably financially sophisticated and as much as possible, financially secure. I think it's really challenging, even for the best person in the world, if they're having a lot of trouble paying their own, mortgage or rent, and you're giving them your checkbook, that puts them in a really tough position, right? So, this isn't where you show your love, is what I'm trying to say, right? That's where your will and who inherits. This is really, you're trying to appoint somebody that's going to be able to manage, your assets for your benefit, right? You're hiring them. I've had a lot of clients that wanted to give all of their children the power at the same time, and I don't recommend that, because what can happen is all the different power of attorneys, if you have multiple, can be liable to each other for what each person does, even if they're not the one actually acting. And the purpose to a power of attorney, to a large extent, is to avoid having to go to court, right? To avoid having to have a conservatorship. But if we've got multiple agents and they disagree with each other, that's one of the things that can make you have to go to court. So that can be a real challenge. So those are things to consider. Another thing that I'll say on all of these documents, one of the most common issues I see is people will name one agent and only one agent. They only have one power of attorney or one executor. Life happens, and we don't always know what's going to happen. And so, like, my father died when he was 43. And so if you only have one person on a power of attorney, and that person, something happens to them where they can't act, then you don't have a power of attorney anymore. So insofar as possible, it's really important to get a backup if you can. That makes a big difference. And then the last thing I would want to talk about, this is again general to our documents, is capacity. A lot of my clients will ask, that when you first get a diagnosis of dementia, or they're in a position where there's a question if somebody can sign a power of attorney or an advance directive or will. So one of the things to note is that there is a capacity that you have to have for a power of attorney or advance directive. It's what we call the power of contract. You have to know what the document does, how it works, and what you're agreeing to, right? Now, obviously, that somewhat scales between, say, a variable annuity, which is really hard to understand for most people, and a simple IOU, right? The capacity is going to be different because how hard it is to understand is a little bit different. But generally, it's considered the same level of capacity. And that capacity is actually determined at the time you sign, right? And so I had one client, I thought we might have to do a conservation, a conservatorship, which is when you basically don't have a power of attorney generally, and you sue somebody to remove their legal rights and put somebody in charge of them. So I went to visit her, though, to see, before we looked at doing that, if a power of attorney, would be something she could sign. And I talked to her, and she was clear as a bell. She had 16 different nieces and nephews. She named them all. She knew exactly what she owned. She knew who she wanted to put in charge. We had everything. She had perfect capacity. And so she signed all the documents, and I kept talking, we continued talking about her care and some other things. And 5 minutes later, she really thought it was 56 and we're seeing Wisconsin, right? But at the moment she signed, she had capacity. So just having a diagnosis isn't enough to say that you don't have capacity. You can have what we call a moment of clarity, right? Which can be really an important thing in that situation. So that's kind of what I would say about power of attorney for finances. But having that doesn't mean somebody can make medical decisions for you. That's a separate document. And a lot of states and for some estate planners are going to use something called a healthcare power of attorney. And that's a document that's similar to a financial power of attorney, but you're appointing somebody that can talk to doctors and look at your records and tell a doctor that you want to you need a procedure, or you don't want a procedure, to put you on a medication or take you off of one or check you into a facility or check you out, right? To make those medical decisions for you if you can. And again, is you can talk to the doctor, what you say goes. It doesn't matter really what's on these documents in that situation, right? But the healthcare power of attorney can be really, really important. There's also a living will. And so a living will is a document that really pertains to end of life. So it's going to have, it's not talking about necessarily right now always. A lot of times it's talking in the future. So it would be if I'm in a persistent vegetative state, right? Then in my heart stop, would I want them to give me CPR or not? Right? It's kind of what you're looking at in a living will. Because the idea being, if I'm in a persistent vegetative state, even if CPR is successful, I'm still in a persistent vegetative state. So a lot of people in that case wouldn't want CPR. They would just kind of want to, be able to pass on. But nothing in a living will is going to hasten your death, unless you would kind of pass away naturally, but the doctors could intervene. You're saying whether you want to or not. And so then in Tennessee, we're allowed to have an advancce directive for healthcare, which combines these two, right? It has a living will. It can have a healthcare power of attorney elements to them, and that's can be a really important document. I'll say some estate planners are going to use more of the healthcare power of attorney. Some just use the will. Some use both, and some use advanced directives. So all of them are valid. If you come from a different state and you have one or the other one, you always want to check your out-of-state documents with a local attorney. But generally speaking, they're going to be valid. So one thing I do think is important on this is that's COVID specific. Is that for a lot of us that have a living will or an advanced directive, one of the questions is going to be, do I want to be on a respirator, right? Maybe not directly, but it's going to talk about, a lot of times it'll talk about kind of breathing machines and things like that. So with COVID, sometimes, some clients would want to go on a respirator where they may not usually want to be on a respirator, right? Because I've had clients that were on respirators and came off and were doing better, right? Where traditionally that would be less likely to happen. So you can either include that in the healthcare power of attorney or advanced directive, or you can use an addendum. And one of the addendums that I really like is through something called the Conversation Project. You can find them at conversationproject.org. And a lot of these discussions at the best of time are really difficult to have with family members. It's really hard to talk about our wishes if we were in these situations. So generally, I think they're a wonderful resource because they are in a position where, they have kind of guides to guide you through these discussions, right? And it really is important to have these discussions because when you're appointing somebody to make these decisions, they're really kind of substituting their judgment for what you'd want. And the more you've talked to them, the more they're going to know. Plus, and I'm sure a lot of you have had to go through this. These are really guilt-inducing, difficult decisions. And so having an explicit conversation about them, I think, can make people a lot more comfortable and reduce some of the guilt. But so their Conversation Project is a wonderful resource in the first place. But they also now have a COVID addendum that you can fill out that you could add to your healthcare power of attorney or your living will. And I think it's a really good resource to consider. It kind of walks you through those conversations and gets that information down. So I would recommend, that we look at that, even if you've got perfectly valid documents. I think that's a useful thing to do. And again, I don't necessarily think you have to go through all your finances with your agent. I think you need to tell them for power of attorney for finances that they are your agent, where the document is, et cetera. But with healthcare, the more you can talk not just to your agent, but to the whole family, I think the better that you are, because nothing kind of tears apart a family as fast as, an agent following what you wanted, but another child thinking that you killed mama, right? That can be really difficult. So as much as everybody's discussed that and is on the same page, I think that makes a big difference. So the next thing we'll talk about is your will. Your will is the document that's going to determine who inherits what when you pass away, right? It does not go into effect until the day you pass. So that's important. And so just because you name somebody doesn't give them any power, right? And so until that date. Now, that date is going to say, whatever I have left over, this is the person I want to inherit. And you're going to go through different types of property, everything from tangible personal property, which is kind of your stuff, right? Which can be the hardest. You know, if you've got family heirlooms and pictures, determining which child or which family member gets that can be harder in some ways. But it's going to talk about that. It's going to talk about who you want to get your real estate, and it'll talk about how you want to distribute your assets, your you know, a lot of times your money and your investments and things to that extent. Again, you have to have capacity to sign a will, but it's actually even lower requirement than a power of attorney or advance directive. You need to know the objects of your bounty, so you need to know who your children are. You need to know the extent of your possessions, so what do you own? And you need to be able to make an organized kind of plan for who you want to distribute them. Now, you can do an all holographic will, which means you write it all out in your handwriting. I would warn you about it deeply. I've seen dozens, and in my time as an attorney, and I would say I've only seen 2 or 3 that were fully correct. These things are complex. It's really easy to mess them up, would be a nice way to put it. You know, the other thing is if there's any typing on it at all, it's not enough just to sign it, and it's not enough just to have a notary. You have to have 2 disinterested witnesses to also witness it for you. And really we'd want to have something called there's a specific affidavit for the witnesses, because if you don't have that, the witnesses can actually have to go to court after you pass away to testify that they saw you sign it, and that they were inside of each other and of you, and that you had capacity to sign, that nobody was, you weren't having undue influence on you, things like that. So there's an affidavit that can avoid that, but you need to have that as well. So now, one of the big questions that people ask, is does everything have to go to will? Can I avoid or probate? Can I avoid probate? Well, wills only control what goes through probate, right? So if you have an asset that's co-owned with somebody else, with like right of survivorship or between husband and wife, that automatically passes the other person when you die. If you have a beneficiary designation on your account, that account is going to go through the beneficiary designations. That's especially important for retirement accounts like IRAs. We rarely want that. We don't ever want that really to go to an estate, and we rarely want that to go to a trust. So it's really important to review the beneficiary designations on your retirement accounts. But one of the things I would say about a trust, a will can be really important, is if you have minors who can't manage money, or you have a person that you're going to leave money to that's disabled, or that's not good with money, or that is on some type of government benefits that they can't have too much money for. The will, instead of leaving it directly to them, can leave it to a trust. And that only happens either through a will or through another trust that owns it. If you're using beneficiary designations, you could skip that. And those can be really important because they can protect it from somebody's debts when you give it to them, or it can protect it from knocking them off of government benefits like Medicaid, because they'd have too much money if you leave it to them. So trust, I think, are a little bit confusing, but you can think of them, they're a different entity through the government, right? The government sees it as different than a person, right? It's like, you can call it Bob. It's its own person, right? And it's got somebody that sets it up and makes the rules called a grantor. It's got somebody in charge of it called a trustee. And it's got somebody that is there to benefit called a beneficiary. All trusts have all 3. And there's a lot of different types of trusts. The most common is called a revocable living trust. And in that one, if I set it up, I'm the one that sets it up. It's for my benefit. And I'm the one in charge of it usually. And so those are really useful for avoiding probate. Because when I pass away, whatever's in that trust, it's going to have language like a will to say who's going to inherit it next. But unlike a power of attorney, The power of attorney ends when you're passed away, right? But the revocable living trust, while I'm alive, I can manage it. And if I can't do it, I have a backup trustee. But when I die, instead of having to go through probate, the revocable living trust determines who gets it next. There's also like irrevocable trust. So in a revocable trust, I can change it at any time. An irrevocable trust is something where it's similar, but if I set it up, I generally wouldn't be in charge of it, and it may not be for my benefit. A lot of times we use these to plan for Medicaid 5 years ahead of time, or to plan for some VA benefits, or some people use it for tax planning. It's a way that you give enough power away that it doesn't count as yours for Medicaid, kind of like you were making a gift to start that 5 years, but it's protected from the creditors of the beneficiary of, say, your children, right? And you get to keep more power. It can be better for capital gains taxes and things like that. The final type of trust that I want to talk about is a special needs trust or a supplemental needs trust. And so we talked about people that maybe are on Medicaid or getting long-term care, let's say through choices. If they receive money, they can be over-resourced, and that can make them lose their benefits. But you can set up a trust where the money's for their benefit, but it doesn't affect their benefit, their qualification. You have to have a separate trustee that's in charge of it, and it can be for them. But those are really, really important. And if you're under 65, you can set up one for yourself, but when you pass away, you pay back to government. If you're setting it up with your money for someone else, you can set it for anybody else and have it either set up where it goes through your will, or you have a separate trust that sets it up itself. But between spouses, you can only set it up in a will. So that's really important. But thank you very much. It's been a pleasure talking to you today, and I look forward to answering your questions in person.
All right. Thank you all so much for joining in. Sorry if there are any technical difficulties. We appreciate your understanding because we too are learning as we go. But I'm going to turn it over to Glen Kyle. He's joining us live, and if you have any questions, I'm going to send you a request to unmute. If you want to unmute, you press *6. It should prompt, and there you can ask Glen any of your questions. Give me 1 second, because like I said, we're all learning here. Unmute all. Okay. You can now unmute yourself by pressing *6, and if you have any questions for Glen, he hopefully will be able to help you out.
Hello? Glen. Hello. This is Francis Mize. I need an address and phone number that I could get in touch with him.
Of course. If you would like to get in touch with Franklin and Kyle Elder Law, you can call them at 865-588
Okay.
3700.
Okay, thank you so much.
You're welcome. And for everyone else, you can also visit them online at franklinandkyle.com. All right. Any more questions?
Yes, I have a question. I was looking at my aunt's trust. She has a revocable living trust agreement, and I'm listed on it. And then her husband, he's deceased now, and she has not changed that, where she has her brother-in-law. So, but she doesn't know where he is. So I probably need to get with an attorney to change this. Is that correct?
Yeah, generally speaking, I mean, it depends on which position you're looking at. I mean, if you're talking about a trustee, the person that would manage it, if you do have somebody in that order that she'd want to remove or change, then yeah, I mean, then I would recommend amending it to remove that person. If you're talking about who inherits in what order, then it may have language in there that if he's not available or what have you. But generally speaking, if she doesn't know where he is now, I would recommend that she updates that trust.
Because, yeah, he was the brother-in-law was the trustee for the husband. I'm the trustee for the wife, and I'm not sure how they set that up. I'll probably have to get an appointment with you and go over this.
Yeah, that'd be great.
Thank you.
Thank you.
I have a question.
Okay.
My cousin was a child, and he left him to be with his biological mother. Well, my auntie raised him. She adopted him and raised him. When she put everything in my daddy's hands to give to him when he, when she would pass away. Well, she passed away, and we can't find my cousin. We looked everywhere, but we can't find him anywhere. I'm not sure, but I think that he was gay and they changed his name. Is there any way we could find him?
That can be challenging, for sure. Sometimes we've even had to get private detectives to look for people on that. In general, I know this isn't going to help you as much. I apologize, but in Facebook stalking, I guess that sounds funny, but a lot of times if you know somebody that would know him, and then you can we've had some success kind of working through that kind of chain of people to try to find them. There are some public information that's out there that you can look up to in public records.
Well, I think he also changed his name. His name was, he asked his mother to change his name. I think at one point in time he had gone to jail for a misdemeanor, but when he came out, he wanted his name changed. And we have a social security number, but I don't know what he may have changed his name.
Well, if you know what, you may not know this, but if you know what county he lived in, to change your name, that is going to be there would be a court record for that, right? Court records are public. And so if you know what county it was in and his old name, you should be able to probably call the county clerk or the clerk for, the judges or the chancellors in that area, probably chancellors, and see if they have a record of it.
Oh, okay. Thank you very much.
So that's what I recommend. And just in general, for everybody, and one of the things that I said in there, but I don't know that I gave enough attention to, if you really want to leave money for the benefit of somebody that's a minor or somebody that's with a disability or for somebody that you don't think can manage it, a lot of people want to leave it to a family member so they can take care of them. But there's a lot of issues that can come with that. If you're leaving it to, I'm leaving it to one son to take care of my daughter and the son wants to keep the money, he can, it's his money, right? Or if he dies or if he gets, he has a stroke, all of those things I vested in him. So that's a lot of times where we'll use a trust where we can leave it for the benefit of the person that can't manage the money, perhaps because they're too young or under disability. We put somebody else to manage it for them. But in that case, it's not the manager, it's not the trustee's money. It's for the benefit. I know that's too late, and I apologize for that. That was just in general. I think that's something that to think about. But I'm sorry you've had that situation. That's very difficult.
I have a question.
Yes, sir.
My question perhaps is more of a tax reporting and IRS question, but I've made a living will as well as a will, and I have a trust fund set up for my grandson. But if I wish to give a family member say $5,000, and how does he report that, and how do I report my gift?
So if you're going to, there would be no reporting for 5,000, right? You can give $15,000 per person per year without it being under the estate. That's the minimum. I mean, that's the amount you can give without having to do any reporting for the estate and gift taxes. Now, that's separate than income taxes. It's separate from capital gains, and that doesn't touch the VA or Medicaid rules. But basically, when you pass away, they add up the amount that you gave every year before that exemption of $15,000. They add it to what your total estate is worth when you pass. And if it's currently worth less than $11.5 million, there's no estate and gift taxes. And if you're married, it's 23. Now that's set to go back down to $5.5 million a person. But most people don't have to worry about the state and gift taxes that much, unless your last name is, Haslett or Frist or something like that. The other thing, though, you do have to be careful about is if you did need long-term care in the next 5 years, or 3 years if you were a wartime veteran, giving that money away would count against you. And so that could make it hard or really, they could really reduce your ability to qualify for the Medicaid program. Now, I don't know your finances, and I don't know your situation. Sometimes those are more appropriate than others, but you do always, when you're talking about gifting, need to look at how that would affect your potential public benefits as well. That was a lot of words. Did that answer that? Okay.
If you're doing it before death, clarify that, Glenn.
Yeah, if you're making the gift, yeah, I was assuming that you were talking about doing it now, and I apologize if that was incorrect. If you're leaving it to them after you pass away, but as long as your total estate plus what you gave above the exemption is less than currently $11.5 million, there won't be any estate and gift taxes.
Hello?
May I ask a
May
question?
I have a question?
That's regarding what you just said?
Yes, ma'am.
I have 6 grandchildren, and they live all over the country, and it's hard to send them gifts now with everything, and I'm not able to get to the post office. So I wanted to open a savings account with their name and my name and put money into it on birthdays and Christmas. Would that affect my estate?
Potentially. It's going to depend on are they minors? Are they of age?
Yes, they're all minors. They're 12 years and under, 12 to 2 years old.
So there's multiple ways you could set up an account for their benefit. You could do like an account transfer to minor, or that's a Uniform Transfer to Minors Act account. Or you could set up like a 529, which would be for their benefit, but it works more like an IRA, right? And you get tax benefits for putting it in there. Doing that, if you don't need Medicaid, if you're not needing in-home care or nursing home or what have you in the next 5 years, there's not going to be an issue with it, and it's not going to be enough money generally to really affect your estate and gift taxes. If you did need help, sorry, go ahead.
I wanted to do it now, and I want to set up a trust because I do have medical issues, and I am alone. My parents and my brother are dead, and they all live out of state. So there's nobody here to care for me, and I'll eventually have to go to a nursing home. But I do have an estate because my parents left me money when they died. So I'm going to be one of the ones that are going to have to come in and talk to you about a trust. But like I was planning on this Christmas opening them all up a savings account in their name along with mine at my local bank. Of course, they all live out of state, so they have no access to it. Could I possibly do that?
Yeah. So what I have to say, there's 2 issues there that are both important. I mean, the first one is minors can't actually own money in their own name, right? And so that was why there's different kind of legal ways that you could have it for their benefit. And some of them, they're kind of the owner and you're a manager of it. And some of it, you kind of keep the power of it. And so those are going to be affecting public benefits different. We could talk, we can talk about that in a little bit more detail. The bigger thing is, I'll say Medicaid doesn't have any exceptions for gifts, right? Even for tithing or what have you. I've never seen them get mad about, really $100 or $200 for Christmases and birthdays, or $50 for Christmas birthdays or things like that. And so if you're talking about something like that, then I think you'd be okay. Otherwise, we want to look at your total assets and try to figure out, how much would be, appropriate. But it sounds like you've got a little bit of a complicated situation. So I don't want to, I have to be careful. I don't want to give you legal advice when I don't know all the details, right? But there's a couple of different ways that you could look at that and structure that. But you do need to be more careful than most, especially if there's a higher chance with a medical condition that you would need help.
Well, thank you. I appreciate it.
No problem. Hopefully that was helpful.
You were.
I have a question. Do you have in your will, can you have your trust embedded in your will so that you can have things designated as a will, as a trust inside of a will?
Yeah, absolutely. Yeah, no, absolutely. There's a lot of distinctions in wills, but one of the big one is what we would call the difference between an inter vivos, which is just a fancy way of saying during life, and a testamentary, which means it's not established until you die, right? And so the kind of most traditional ones were really the testamentary. So they'd be set up in your will to benefit somebody going forward. And often that's somebody that has creditor issues or has a disability and needs means tested, benefits, or somebody that's too young to manage it, or just somebody who's bad with money, right? And so that's a way that it's your money until you pass away, but when you pass away, instead of you want to help that person. So you want to set up that trust to benefit them and only them, but you want to put somebody else in charge of it. And so that's very common. You can also set them up during life, but those are going to do slightly different things. That's like a revocable living trust. And it can be a will substitute. Everything in that trust, when you pass away, you don't have to go through probate or the will. It would just pass. It basically has the same kind of rules in it that a will would have. And the next trustee takes it over and passes it outside of probate court. But like you were saying there, you could still have that when it passes away. Maybe it's for my benefit for my lifetime, but I still want to benefit somebody who's bad with money or has creditor issues or what have you. It can set up a separate trust for them. So by all means, I set up more trust really in wills than I do otherwise.
Thank you.
I have a question.
Okay.
My grandson passed away in Kentucky, and he didn't have any kind of a will or anything set up, and they're telling us that we need an estate lawyer to help with his working comp. Is there one here in Tennessee that we could speak with, even though it happened in Kentucky? His truck jackknifed and it killed him.
No, you need a Kentucky attorney. So the probate rules and the estate administration is what we call it. We do that, and a lot of estate planning attorneys do that. But every state has different laws, and they can differ fairly considerably. And so, if you got a Tennessee attorney that's licensed in Kentucky, you could do that. But you really want somebody that's taken the Kentucky bar and could go before a Kentucky court and is admitted to practice in Kentucky.
Okay, but he lived in Tennessee, in Knoxville. He just died in Kentucky.
I apologize. Does he have real estate?
No, he had nothing. He was just a truck driver. He really didn't have anything. He just drove trucks.
Who told you you had to have
children or any? He wasn't married. He didn't have children. Anything.
So was he just passing through Kentucky at the time?
Yes, he was going on one of his routes, and someone ran out in front of him, and he tried to stop, and his truck jackknifed.
But his home was in Kentucky. I mean, it was in Tennessee.
Yes.
You could see a Tennessee a probate or a state attorney for that, for sure.
Okay.
Yeah, and part of it's going to come down to what he actually owned too. On whether you needed to do that, but to get a hold of his bank account or vehicles or what have you. Yeah, a Tennessee attorney could help in that situation.
Okay. Thank you so much.
No problem at all.
All right, we have time for one more question. If anyone even has one.
I have a question.
Okay.
Oh, hello. I'm the executrix for my father who lives in Arkansas, and my stepmother has a right of survivorship in the home. I live here in Knoxville. Can you tell me, should I have an attorney or look at that here in Tennessee or Arkansas, or something about what that means about right of survivorship in the home?
Okay, so a couple things. So, home is in Arkansas. It's going to be subject to Arkansas law, right?
Yes.
And there can be some differences in that. So if you wanted to talk to an attorney, it would be an Arkansas attorney. I can't tell you about Arkansas law, but I can tell you generally in the American system, certainly most states, survivorship means is that it's for two co-owners. And if one of them passes away, the other one just inherits it, right? It's already kind of theirs. It doesn't go through like that. So basically, when the first person dies, the second person gets the house.
Okay.
If that's not something, and that can be difficult, especially in families, because to some extent it can end up being, if you don't have a will, a race to die second, right? Because you can imagine, if I don't have a will, if I pass away, there are certain rules called the intestacy rules that'll say who inherits, and it's almost never going to include stepkids, right? And so if my wife and I if I pass first and I leave it to my wife, it would go to her kids. If she dies first and I inherit it, then without a will, it would go to my kids, right? And so a lot of times you want to try to get a more blended estate plan, which can be a little bit more complicated, but that can be important, especially if you wanted to split it between the different sides or have trust for the other spouse. So depending on what their goals are, it could definitely be worth them talking to an Arkansas estate planning attorney about that.
Okay, thank you.
Thank you.
Awesome. Well, thank you guys so much for joining in with us today. Virtual round of applause for Glen Kyle. We really hope that next year we'll be in person, but we shall see. We'll see. But please join us again next week at 10 a.m. for our next speaker, Dr. Monica Crane. She'll be speaking about normal aging versus dementia. And once again, if you'd like to contact Glen, you can call his practice at 865-588-3700, or you can go to franklinkyle.com. They're also in the senior service directory. So all over the place, you can find their contact, or you can call us at the office and we'll help you out. Once again, thank you all, and we will see you next time.
Thank you.
Thank you so much.